Welcome back to US Update Immigration, your trusted source for the latest developments in American immigration policy. Before we dive into today's critical discussion, I want you to imagine waking up one morning to discover that the fundamental rules about American citizenship have been completely rewritten. For over a century and a half, if you were born on American soil, you were automatically an American citizen. That was the promise, the guarantee, the bedrock principle that defined what it meant to be American. But what if I told you that this centuries-old tradition has been dramatically altered and the changes are happening right now as we speak? Stay with me because what I'm about to share with you today could fundamentally affect millions of families across the United States and around the world who dream of building their lives in America. Today is December 11th, 2025. And we're going to talk about one of the most significant and controversial changes to American immigration law in modern history. This isn't just another policy tweak or minor adjustment to visa processing times. What we're discussing today strikes at the very heart of what defines American citizenship and who gets to call themselves an American. The implications are profound, the legal battles are ongoing, and families across the nation are living in uncertainty about their children's future. Whether you're an immigrant, a visa holder, someone planning to come to the United States, or simply someone who cares about the direction of American immigration policy, this video contains information you absolutely need to know. Following Donald Trump's electoral victory in November 2024, experts and analysts across the political spectrum anticipated significant changes to the United States immigration system. Those predictions have now materialized in ways that few could have fully imagined. As we approach the end of 2025, the United States finds itself navigating unprecedented territory, marked by fundamentally reformed citizenship laws that challenge more than 150 years of constitutional interpretation and practice. For generations, stretching back to the aftermath of the Civil War, the principle was crystal clear and honestly, seemingly unshakable. If you were born within the borders of the United States, you automatically became an American citizen. It didn't matter who your parents were, what their immigration status might be, or how they arrived in the country. The soil itself conferred citizenship. This principle, enshrined in the 14th Amendment to the Constitution, was adopted in 1868 to ensure that formerly enslaved people and their descendants would be recognized as full citizens with all the rights and protections that citizenship entails. For over a century and a half, this interpretation remained largely unchallenged and formed the foundation of American citizenship law. However, in June 2025, after years of heated debate, extensive litigation, and repeated political promises, the Supreme Court of the United States issued a ruling that facilitated President Trump's executive order to significantly alter birthright citizenship. This adjustment carries profound implications that will reverberate through families, communities, and the very concept of national identity for generations to come. In this video, we're going to comprehensively explore how these dramatic changes unfolded over the past year. We'll examine exactly what the executive order entails, break down the specific language and requirements it introduces, identify who it impacts and how their lives are being affected, and analyze why this might represent one of the most significant transformations to United States immigration and constitutional law in recent history. If you're finding value in this content and want to stay informed about every development in American immigration policy, I encourage you to hit that subscribe button and click the bell icon so you'll receive notifications whenever we post new updates. Your engagement helps us continue bringing you this crucial information. So, please take a moment to like this video and share it with anyone who might benefit from this knowledge. Now, let's explore this complex and evolving situation in depth. When Donald Trump returned to the White House in January 2025, he wasted no time resurrecting one of his most controversial campaign promises from previous election cycles. On his very first day back in office, January 20th, 2025, he signed an executive order with the formal title Protecting the Meaning and Value of American Citizenship. This wasn't a subtle policy adjustment or a minor administrative change. This was a bold and sweeping attempt to fundamentally reinterpret the 14th Amendment to the United States Constitution. The 14th Amendment, which has stood for over 150 years, includes language stating that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. For more than a century, this has been interpreted to mean that almost all children born on American soil automatically receive citizenship regardless of their parents' immigration status. There were only extremely narrow exceptions, such as children of foreign diplomats who are not subject to United States jurisdiction. Trump's executive order sought to radically reinterpret this constitutional provision. The decision wasn't entirely unprecedented in the sense that Trump had floated this idea during his previous term in office, but the scope and immediacy of this executive order were unlike anything previously attempted. The order explicitly stated that, effective 30 days from January 20, 2025, only children with at least one parent who is either a United States citizen or a lawful permanent resident would automatically receive citizenship at birth. Let me emphasize the significance of this change under the new interpretation. Being born in the United States no longer guarantees citizenship, unless at least one of your parents meets specific immigration status requirements. This represents a fundamental departure from how birthright citizenship has been understood and applied throughout American history. The executive order officially took effect on February 19, 2025, introducing a jarring new reality for countless families across America. From that date forward, a child's birthplace within the United States would no longer serve as an automatic guarantee of citizenship. The determining factor shifted from location of birth to the immigration status of the parents. Only those children with at least one parent who is a United States citizen or holds lawful permanent resident status, commonly known as having a green card, would be recognized as citizens at birth. The scope of the order was deliberately comprehensive and far-reaching. It explicitly covered children born to parents holding non-immigrant visas, including international students pursuing their education in America, temporary workers contributing to the American economy, and even tourists visiting the country. The order made clear that lawful presence in the United States was not sufficient. Even if parents were in the country completely legally, following all rules and regulations, their children born in America would not receive automatic citizenship unless the parents met the stricter requirements of citizenship or permanent residency. The executive order also directed federal agencies to fundamentally change their procedures. Agencies were instructed to immediately stop issuing citizenship documents, such as passports and social security cards, to children who didn't meet the new requirements. This created an immediate administrative challenge. Hospitals and state agencies that process birth registrations found themselves suddenly responsible for verifying parental immigration status at the time of birth. This verification requirement introduced considerable administrative confusion, placed new burdens on healthcare providers and government workers, and generated significant worry and anxiety for families who found themselves caught in this rapidly changing landscape. The legal response to the executive order was swift and fierce. Civil rights organizations, recognizing the profound constitutional questions at stake, quickly mobilized. A broad coalition of states, led primarily by states with Democratic leadership but including some others concerned about federal overreach, launched multiple lawsuits contending that the executive order was fundamentally unconstitutional. These legal challenges argued that the president lacks the authority to reinterpret the Constitution through executive action, that the 14th Amendment's meaning is clear and cannot be changed without a constitutional amendment, and that the order would create chaos for families, healthcare systems, and government agencies alike. In several states across the country, federal judges responded quickly to these legal challenges. Multiple judges issued nationwide injunctions, court orders that temporarily halt the enforcement of a policy across the entire country, not just within their specific jurisdictions. These injunctions created a period of uncertainty where the executive order was officially policy, but couldn't be implemented while the legal challenges worked their way through the court system. Then came the pivotal moment that changed everything. On June 27, 2025, just over 5 months ago from today's date, the Supreme Court of the United States delivered a crucial ruling that would determine the fate of birthright citizenship across most of America. The court's decision was nuanced and in some ways strategic. Rather than directly addressing whether the executive order itself was constitutional, a question that would have required the court to definitively interpret the 14th Amendment. The Supreme Court focused on a narrower procedural question about the power of lower federal courts to issue nationwide injunctions. In its ruling, the Supreme Court significantly restricted the authority of lower courts to issue these broad, nationwide injunctions. The practical effect of this decision was profound. By limiting the scope of injunctions that lower courts could issue, the Supreme Court effectively allowed Trump's executive order to take effect across most states, while legal challenges to the underlying constitutionality of the policy continued to proceed through the court system. This meant that the policy could be implemented and families would be affected even as the fundamental legal questions remained unresolved. The ruling created a patchwork implementation across the country. The order became enforceable in the vast majority of states, fundamentally changing how citizenship is granted to newborns in those jurisdictions. However, it remained blocked in a handful of states, including Colorado, where state officials had joined lawsuits challenging the policy and where state-level injunctions remained in effect. President Trump, not surprisingly, celebrated the Supreme Court's ruling as a monumental victory. In public statements, he characterized it as a triumph for the Constitution, for the separation of powers among the three branches of government, and for the rule of law as he interpreted it. He emphasized that the ruling would enable his administration to implement what he described as substantial and necessary changes to immigration and citizenship policy. The effects of this new policy have varied dramatically depending on where in the country you happen to live or give birth. In regions like Colorado and a few other states where government officials actively participated in lawsuits against the executive order, birthright citizenship protections remain intact, for now. In these states, a child born on their soil still automatically receives citizenship regardless of the parent's immigration status, just as has been the case for over a century and a half. However, in the majority of states across America, the new restrictions are actively being implemented and are causing tremendous uncertainty for immigrant families and what are known as mixed-status households, where family members have different immigration statuses. The executive order particularly impacts several vulnerable groups. Children born to undocumented immigrants face the most precarious situation as their parents, by definition, do not meet the requirements for their children to receive automatic citizenship. Children born to temporary visa holders, including those whose parents are international students, workers on temporary employment visas, or even long-term residents who have lived in America for years but don't yet have green cards, also find themselves excluded from automatic citizenship. Immigrant communities across the country report heightened levels of fear, anxiety, and confusion. Many families are genuinely uncertain about their United States-born children's citizenship status and what that means for their access to essential government benefits, healthcare, education, and their long-term future in the only country many of these children will have ever known. Some parents are avoiding hospitals for prenatal care or childbirth out of fear that their immigration status will be scrutinized or reported. Others are seeking legal advice to determine whether their children might face the nightmare scenario of statelessness, where they are recognized as citizens of no country at all. When we look at this change from an international perspective, the United States has now positioned itself much closer to how most other developed nations handle birthright citizenship. The United States was actually somewhat unusual in maintaining unrestricted birthright citizenship based solely on place of birth. Most European and Asian countries have long required at least one parent to be a citizen or permanent resident for a child to automatically attain citizenship at birth. By implementing these restrictions, the United States now aligns more closely with the policies of nations like the United Kingdom, France, Germany, Australia, and Japan. That said, the Americas as a region have historically been different. Countries throughout North and South America have generally maintained more open birthright citizenship policies, reflecting the history of immigration and nation-building in the Western Hemisphere. However, with the United States imposing these new restrictions, only a handful of countries in the Americas, most notably Canada and Mexico, still grant fully unconditional citizenship at birth based solely on location. This represents a significant shift in how the Western Hemisphere approaches questions of citizenship and belonging. The timeline of these dramatic changes is worth reviewing in detail to understand how rapidly this transformation occurred. On January 20, 2025, less than a year ago, President Trump signed the executive order ending birthright citizenship for most children of non-citizens. The order included a 30-day implementation period, meaning that the actual policy changes took effect on February 19, 2025. For births occurring after that date, the new rules applied, fundamentally changing the citizenship status of children born to parents who didn't meet the stricter requirements. In the weeks and months following the order's announcement, federal courts across the country became battlegrounds. Multiple federal judges issued injunctions attempting to block the policy's implementation. Civil rights organizations, including the American Civil Liberties Union, immigrant advocacy groups, and legal organizations, teamed up with over 20 states to challenge the policy through coordinated litigation. These legal challenges raised fundamental questions about presidential authority, constitutional interpretation, and the separation of powers among the branches of government. Then, as mentioned earlier, came the Supreme Court's decision on June 27, 2025, which enabled the order's implementation in most parts of the country by restricting the power of lower courts to issue broad nationwide injunctions. While legal battles persist in a handful of states where injunctions remain in effect, and while the underlying constitutional questions have not been definitively resolved, the practical reality is that for most of America, birthright citizenship, as it was understood for over 150 years, no longer exists. This conflict is far from resolved, and we are still in the middle of an ongoing legal and political battle over the future of American citizenship. Advocates for immigrant rights have not given up. They have pivoted their strategy to focus on class action lawsuits aimed at safeguarding the rights and interests of families directly affected by the executive order. These lawsuits seek to establish that the children born under the new regime are being denied constitutional rights, and that the executive order itself exceeds presidential authority and contradicts the clear language of the 14th Amendment. Many constitutional scholars and legal experts believe that the Supreme Court's June ruling, while significant, was deliberately narrow in scope, by focusing on the procedural question of nationwide injunctions rather than the substantive question of whether the executive order is constitutional. The court may have been buying time or avoiding a decision it wasn't ready to make. Most observers believe that the core constitutional issue, the fundamental question of what the 14th Amendment means and whether the president can reinterpret it through executive action, will eventually return to the Supreme Court for a definitive ruling. When that happens, the court will be forced to directly confront the question it sidestepped in June. Meanwhile, families across the United States remain in an agonizing state of limbo and uncertainty. The executive order has forced the implementation of new policies in schools, hospitals, social service agencies, and government offices. Healthcare providers are now required to verify and document parental immigration status, which is, raising privacy concerns and fears about how that information might be used. Schools are grappling with questions about enrollment and services for children whose citizenship status is unclear or disputed. Social service agencies are trying to determine which children qualify for benefits and which don't, based on their citizenship status. Perhaps most troubling is the very real possibility that some children may face statelessness. If a child is born in the United States to parents from a country that grants citizenship based on parental citizenship rather than place of birth, and that child is now denied American citizenship, under the new rules, the child might not be recognized as a citizen by any country. Statelessness is one of the most vulnerable conditions a person can face in the modern world, leaving individuals without the protection of any government, unable to obtain passports or travel documents, and often unable to access basic services. The confirmation and implementation of the end of traditional birthright citizenship signals what many historians and legal scholars believe is a significant turning point in American law and American identity. fueled by President Trump's executive order and enabled by the Supreme Court's ruling on nationwide injunctions, the United States has shifted away from a long-standing tradition that previously distinguished it on the international stage. The policy that welcomed generations of immigrants and their children, the policy that told the world that birth on American soil made you American, has been fundamentally altered. The debate over whether this change is justified, whether it represents a proper interpretation of the Constitution, and whether it serves America's interests, is far from over. The legal battles will continue, potentially for years. The political debates will rage through upcoming election cycles. The academic and scholarly discussions about constitutional interpretation will fill law journals and courtrooms. And most importantly, the very real human consequences for families, for children, for communities, and for the nation's identity and character will continue to unfold over the coming years and decades. What does this mean for you if you're watching this video? If you're currently in the United States on a temporary visa and you're expecting a child or planning to have children, you need to understand that your child may not automatically receive American citizenship simply by being born here. You should consult with an immigration attorney to understand your specific situation and what steps you might take to secure citizenship or legal status for your child. If you're considering coming to the United States for education, work, or other purposes, and you're thinking about starting or expanding your family while you're here, this policy change is something you absolutely must factor into your planning and decision-making. If you're an undocumented immigrant living in the United States, the stakes are even higher. Children you have in America may not receive the citizenship and the protections that children born just months earlier would have automatically received. This creates incredibly difficult decisions for families about their future and their children's future. If you're a United States citizen or lawful permanent resident, your children will still receive citizenship, so the direct impact on you is less severe. But you may still find yourself navigating a more complex system and living in communities where many of your neighbors and friends face these uncertainties. For everyone watching, regardless of your immigration status or citizenship, it's crucial to stay informed about these rapidly evolving policies. Immigration law is complex under the best of circumstances, and during periods of significant change like we're experiencing right now, it becomes even more critical to have accurate, up-to-date information. That's exactly why we created US Visa Updates. Our mission is to provide you with clear, comprehensive, and timely information about every significant development in American immigration policy. We will continue to monitor this situation closely and bring you updates as the legal challenges progress, as new court rulings are issued, and as the practical implementation of these policies evolves. We'll also continue providing detailed information and guidance on all aspects of the United States immigration system, including visitor visas such as B1 and B2 work visas, including L1A, L1B, and H1B student visas, green card processes immigrant visas including EB1, EB2, EB3, EB4, and EB5 employment-based categories as well as family-based immigrant visas. Understanding the steps involved in the United States immigration process, visa application requirements, processing times, necessary forms, associated fees, and countless other important details is absolutely essential for anyone navigating this complex system. Before we conclude, I want to briefly mention another significant development that's also reshaping American immigration in 2025. Though it hasn't received quite as much attention as the birthright citizenship changes, family reunification has traditionally been considered the backbone of family-based immigration in the United States. For decades, the policy has allowed United States citizens and lawful permanent residents to sponsor immediate family members, including spouses, children, parents, and siblings, for permanent residency through the I-130 petition process. While this process has always required extensive documentation, background checks, and patience, it has generally been grounded in the principle that uniting families is a national priority and a fundamental American value. However, as we approach the end of 2025, this long-held principle is also being reevaluated under new directives from the Trump administration. the Department of Homeland Security and United States Citizenship and Immigration Services have been instructed to apply what officials describe as enhanced scrutiny to all I-130 petitions. So, this represents a broader shift in immigration enforcement philosophy that extends beyond just birthright citizenship. The updated policy framework for family-based immigration introduces, numerous changes that collectively signify a major departure from established norms and practices. Revised I-130 petition forms now require substantially more detailed personal and financial information from both the petitioner, the person doing the sponsoring, and the beneficiary, the person being sponsored. The level of documentation required has increased significantly, and honestly, processing times are expected to lengthen as a result of the more intensive review process. Denial rates for these petitions are likely to increase as adjudicators apply stricter standards to determine whether family relationships are genuine and whether sponsors can adequately support their family members. These changes to family-based immigration will be the subject of future videos on this channel, as they deserve their own detailed analysis and explanation. However, for right now, as of today, December 11, 2025, the reality is that birthright citizenship as America has known it for over 150 years has been fundamentally altered in most of the country. Families are living with the consequences of these changes, children's futures are being shaped by them, and the national conversation about who is American and what it means to be American continues to evolve. Thank you so much for watching today's video on U.S. visa updates. If you found this information valuable, helpful, or important, I encourage you to show your support by hitting that like button, sharing this video with friends, family members, or anyone in your community who might benefit from this information would be incredibly helpful in spreading awareness about these critical changes. And if you haven't already subscribed to US Update Immigration, please take a moment to do so right now. Click that subscribe button and make sure to hit the bell icon so you'll be notified immediately whenever we post new content. We're committed to keeping you informed about every significant development in American immigration policy, and your subscription ensures you won't miss any crucial updates. The immigration landscape is changing rapidly, and staying informed isn't just helpful, it's essential. We're here to help you navigate these complex and often confusing changes, providing you with the knowledge you need to make informed decisions about your future and your family's future. Thank you again for trusting US Update Immigration as your source for immigration information.